Remember, based on past experience, these are not heavily tested in the exam. So, I'll just tell you about several types of law in Hong Kong, including common law, equity, mercantile and commercial law, ordinances, subsidiary legislation, and customary law. The most important thing is to know these names. Remember, based on past experience, these are not heavily tested in the exam. So, I'll just tell you about several types of law in Hong Kong, including common law, equity, mercantile and commercial law, ordinances, subsidiary legislation, and customary law. The most important thing is to know these names. What is common law? Common law refers to a legal system that is established based on social customs and traditions rather than by statute or by the authority of the sovereign. It is developed in the law courts through successive judges. The authority of the common law is derived from its long usage and is cemented by the doctrine of precedent. What is legal precedent? In each trial, judges and courts will annotate the laws in a certain way, such as the trial results and methods, which become case examples. This is called case law. Where did common law originate from? It originated in England. In simple terms, common law came first, and then based on judgments of common law, it evolved into case law. What is the meaning of equity? Common law may sometimes have some problems or loopholes. When the common law is unable to cover certain situations, discretion is needed to remedy them. This is called equity. Equity is usually used simultaneously with the common law. However, if there is a conflict between the two, equity generally prevails. What are the 4 types of applications of equity in the financial services industry? Remember, in the exam, there are 4 types. The first is called injunction. What does that mean? It means that there is an order that prohibits someone from doing something, and this order is issued by the court. Once the court issues an injunction, the person cannot do that thing anymore. The complete opposite of an injunction is a specific performance, which means that the court orders someone to do something to fulfill their contractual obligations. When a specific performance is issued by the court, the person must follow the court's instructions. The third type is equitable rescission. When a contract has some problems and both parties do not want the contract to be effective, they can rescind the contract. What does rescission mean? It means that everything required by the contract is no longer necessary, and it returns to the state before the contract was made. For example, if I intended to buy insurance from you and we signed a contract, but now we have decided to rescind the contract, I don't have to buy insurance and I don't need to give you any money, and you don't have to provide me with any insurance. The fourth type is rectification. When I need to clarify the content of the contract, such as how the contract should be executed, I can ask the court to interpret the contract and determine how the contract should be carried out. This is called rectification. As for mercantile law and commercial law, they are not usually tested in exams. Based on past experience, I have never seen them being tested. The main focus is on 2 types of commercial law that often affect the financial services industry, which include the Sale of Goods Ordinance and the Bills of Exchange Ordinance. In Hong Kong's legal system, it includes the primary legislation, which refers to the most important laws and is also called Ordinance. For example, the Trade Descriptions Ordinance and Securities and Futures Ordinance are both primary legislation. So who formulates these laws? As you may know, the Hong Kong Legislative Council passes the laws. We often see legislators voting in meetings on TV, which is the Legislative Council. Laws passed by the Legislative Council are called Ordinance. After the Legislative Council passes the law, the Chief Executive will listen to their opinions and enact the ordinance. The Chief Executive also needs to sign and confirm it. However, if the Legislative Council does not pass the law, the ordinance will not come into effect. What's the difference between subsidiary legislation and primary legislation? Subsidiary legislation refers to some laws are made by a process of delegation from LegCo to other bodies. For example, the Legislative Council passed the SFO, Securities and Futures Ordinance, which requires the establishment of the SFC, Securities and Futures Commission, and the formulation of various regulations and restrictions. As there are many details involved, the Legislative Council cannot complete all the work, so the power of making these legal details is delegated to the SFC. After the SFC drafts the subsidiary legislation, such as regulations on short selling or rules on issuance, it is submitted to the Legislative Council for approval. Once the Legislative Council passes the subsidiary legislation, it becomes effective and is called subsidiary legislation. Conversely, if the Legislative Council does not pass the subsidiary legislation, the draft formulated by the SFC will not become law. Remember, what is called judiciary. The judiciary is responsible for determining whether a person is guilty or innocent. The court system we often talk about is actually called the judiciary system. So, what does independence of the judiciary mean? Under Hong Kong's judicial system, the courts in Hong Kong do not need to obey the chief executive, the government, or the Legislative Council. Hong Kong's courts are independent of all other parts of government. So, is the court a government department? No, the court is not a government department. Are judges appointed for political reasons? Do they need to be loyal to the party? In theory, the judgments made by judges are based entirely on legal principles and precedents. Judges will not yield to pressure from the government, Legislative Council, public, media, or other groups. Therefore, the judgments made by the court are independent and fair. This is called independence of the judiciary. However, currently, judges of all levels of courts are required to take an oath of allegiance to the Hong Kong Special Administrative Region of the People's Republic of China in accordance with the law. There are many types of laws in Hong Kong, and criminal law is one of them. So what is criminal law? Criminal law mainly deals with crimes that harm public interests. Additionally, criminal law defines how suspects may be investigated, prosecuted, tried, and punished. Who files lawsuits and imposes punishments? Lawsuits are filed by the Department of Justice, but only the court can try and punish. The court has the power to impose penalties, and this power cannot be delegated to any individual or body. What is the goal of criminal law? The aim is to punish those who violate the law. As you may have seen in TV dramas, evidence is required to prove a crime. In addition, a prerequisite for a case is that it has to be proved beyond reasonable doubt. What kinds of crimes fall under criminal law? For example, murder, arson, and corruption are all types of crimes under criminal law. If you commit a crime, do you have to go to jail? Not necessarily. There is a chance of imprisonment, but there is also a chance of not being imprisoned. Punishment under criminal law can be light or severe, such as a fine for jaywalking. What is the biggest difference between criminal law and other laws? The Department of Justice or government-appointed agencies prosecute criminal cases, and individuals cannot initiate criminal proceedings. Additionally, violating criminal law can result in imprisonment. For example, if I think you broke my window, but it was not intentional, in this case, I cannot sue you based on the criminal law. However, if there is evidence that you intentionally damaged my property, then I would report it to the police. The police would inform the Department of Justice, and it would decide whether to prosecute. Intentional destruction of property falls under criminal law, but if you want to claim compensation for accidental damage to property, that would be under civil law. What is civil law? The focus of civil law is to provide remedies for individuals or businesses that have suffered loss as a result of the actions of another person. For example, if you accidentally break my window, I can seek compensation for the damages through civil law. Since the goal is to compensate for losses, less evidence is required compared to criminal law. The plaintiff can prove their claim based on a balance of probabilities. In other words, the court considers whether it is likely that the situation occurred, how much compensation is needed, and how to make the compensation, etc. Therefore, civil cases are relatively simple and easy to handle. Who can sue under civil law? The person who has suffered the loss. Can imprisonment be sentenced under civil law? Remember that civil law never involves imprisonment, but is mainly concerned with how to compensate those who have suffered losses as a result of the actions of another person. Through this chart, we can compare the differences between criminal law and civil law. Remember, the purpose of criminal law is to punish those who have committed a crime, while civil law only requires to provide remedies for individuals or businesses that have suffered loss as a result of the actions of another person. In terms of the judicial system, only the court can handle criminal cases, while civil cases can be heard in court or by administrative tribunals. What falls under administrative tribunals? Examples include the Lands Tribunal and the Market Misconduct Tribunal. Of course, some larger and more serious civil cases can also be handled in court, such as disputes over wills and inheritance. Also, note that plaintiff or prosecutor refers to the person who brings the case. In criminal law, the plaintiff is the Department of Justice or state-appointed authorities. In civil law, refers to individuals or businesses who suffered loss. Regarding the burden of proof, in criminal law, the standard is very high and requires excluding all possibilities, beyond reasonable doubt, and having sufficient evidence to prove that you have committed the crime. In contrast, civil law is much simpler. Civil law is based on a balance of probabilities, which means if it is more likely that something happened, then the court will rule in favor of the plaintiff. Finally, remember that in terms of punishment, civil law will never result in imprisonment, while criminal law may result in imprisonment. Sure, how can criminal law and civil law be applied? Firstly, it should be remembered that criminal and civil grounds may occur in the same case. For example, in a previous case, if you intentionally broke my window, I could call the police to charge you, and the court could sentence you to imprisonment or community service. This would be a criminal case. At the same time, my window was indeed broken, so I would also need to be compensated for my loss. Therefore, I would file a private lawsuit and demand that you compensate for my loss. This would be a civil case. Therefore, criminal and civil grounds may occur in the same case and may require two separate trials. What is contract law? How do we determine what is a contract and what is not a contract? In the financial world, many transactions are considered contracts. There are several basic elements to a contract. First, there must be two or more individuals, generally consisting of a buyer and a seller, each with at least one person, and their identities can be individuals, companies, natural persons, or legal persons, etc. This is a legally binding agreement, which means that the content, services, or details of the transaction discussed must all be legal, reasonable, and fair, and the contract can be made orally or in writing. Once a contract is entered into, both the buyer and seller are responsible for the contents of the contract and can require the other party to perform. So remember, both parties have obligations. For example, if I promise to send you something, but don't end up sending it, is it a contract? Can you force me to do it? No, because in a contract, both parties must have obligations. So what belongs to a contract? For example, buying and selling stocks, buying I-bonds, promising to manage a fund, buying and selling leveraged foreign exchange are all contracts. Why are they considered contracts? Because they are recognized by law and can be enforced, both parties have obligations, and generally there are buyers and sellers. What does fiduciary or fiduciary relationship mean? Fiduciary refers to a person who owes another person duties of good faith, trust, confidence, honesty, and care. Fiduciary relationship is one in which one person has a duty to act for the benefit of the other on matters within the scope of their relationship. In simple terms, the fiduciary is acting on behalf of another person, handling matters, and ensuring that the other person receives the benefits they are entitled to. This relationship is called a fiduciary relationship. Lawyers and clients are a good example. When a client appoints a lawyer to handle legal matters, the lawyer has a responsibility to handle the client's problems, provide the most appropriate legal advice based on the client's situation, and handle relevant legal documents. Other everyday examples include stockbrokers and clients, principals and agents, trustees and beneficiaries. Both parties have established this type of fiduciary relationship. What's the difference between agency law and fiduciary relationship? Remember, the agency relationship in the agency law is also a type of fiduciary relationship. However, this type of fiduciary relationship has an additional requirement, which is the presence of a commercial element or interest. For example, if I ask a real estate agent to buy a property and I trust him very much and also give him a commission, then the real estate agent will work for me, which means he will help me find a property. This is a fiduciary relationship with a commercial element, which we call an agency relationship. Now, suppose you trust someone in your household very much and ask them to help you register for the 2C exam and buy study materials. Is this an agency relationship? The answer is no, because the person in your household is not involved in any commercial interest when helping you, so they are not part of an agency relationship. To repeat, a fiduciary relationship with a commercial interest is an agency relationship. How is agency law applied in the financial industry? As mentioned before, the relationship between a stockbroker and a client is a type of agency relationship. The stockbroker acts as an agent for the client, who gives them money to buy stocks, and the broker can earn commissions from providing this service. At the same time, there is also an agency relationship between the stockbroker and the firm they work for. Why is that? The stockbroker helps the stock company do business, so they become an agent for the company, responsible for finding clients and conducting transactions. The firm, in turn, provides compensation or commissions to the broker. Therefore, it is also considered an agency relationship. In agency relationships, there are two roles. One is called the agent, and the other is called the principal. What is the difference between the principal and the agent? The principal is the person who gives orders and instructions to someone to do something, while the agent is the person who listens to orders and does things for someone else. Remember that the principal must provide benefits to the agent, such as salary or commission. There is always some kind of payment. In addition, the principal is responsible for the actions of the agent. For example, if I open a stock brokerage firm and hire a stockbroker, but the stockbroker cheats a client who later complains to me, am I responsible for the actions of the agent? The answer is yes. Alright, so what is the law of tort? I mentioned before that many things in the financial world are based on contractual relationships. However, sometimes problems arise where the parties involved don't have a contractual relationship. What does that mean? Does it sound confusing? For example, let's say one day I accidentally push a window out of my house and it falls on a pedestrian, injuring him. Do I have any relationship with the injured pedestrian? We have no relationship, but my action did cause them harm and they had to go see a doctor. In this case, I have violated the pedestrian's rights, which is called tort. In cases of tort, there must be no contractual or business relationship between parties, but one party suffers loss or damage as a result of the act of the other. The tort of negligence is most directly related to the securities and futures industry. What is tort of negligence? Tort of negligence is one committed as a result of a failure to observe the standard of care expected under law in a particular case. Why is tort of negligence related to the securities and futures industry most directly? Although most activities in the securities and futures industry are contractually bound, there may be situations where there is no contract, but losses may occur. For example, if a stock analyst provides some false opinions, but someone else listens to their advice and buys the stock, they may later discover that the information provided by the analyst was incorrect. In this case, the stock analyst may be sued for tort of negligence. What is the employment law? As the name suggests, the employment law is the law that governs the relationship between employers and employees. This relationship obviously involves two roles, one is the employer and the other is the employee. They both have a contractual relationship because both parties need to contribute and it involves money and commercial elements. So, what are the responsibilities of both parties in the employment relationship? For the employer, they must provide the employee with remuneration, a safe working environment, and assist the employee in completing their job. Any expenses, losses, and liabilities incurred while performing his duties will have to be compensated by the employer. What are the employee's responsibilities to the employer? The employee must demonstrate their skills and competence and be faithful to the employer and not harm the employer's interests. If the employer and employee do not fulfill the above responsibilities, it may be illegal and may also violate the contractual relationship between the two parties. Alright, after understanding Hong Kong's laws, this section will talk about Hong Kong's court and tribunal system. I believe many of you have seen it on TV. In Hong Kong, the Court of Final Appeal is the highest court, headed by the Chief Justice. Underneath the Court of Final Appeal in Hong Kong, there is High Court. The Court of Appeal and the Court of First Instance comprise the High Court. So what does the Court of First Instance do? The Court of First Instance initially handles extremely serious cases, including murder, armed robbery, and complex commercial fraud cases. A well-known example is the Young Key case, in which the Court of First Instance made the ruling. The Court of First Instance has unlimited jurisdiction in respect of criminal and civil cases, and also hears appeals from tribunals and the magistrates' courts. And what about the Court of Appeal? As the name suggests, the Court of Appeal hears appeals including both civil and criminal appeals. These appeals are from lower courts such as the magistrates' courts and the district courts. If someone is dissatisfied with a ruling from a lower court and requests an appeal, the case will be referred to the Court of Appeal for handling. What does the district court do? The district court is responsible for hearing medium-level criminal cases, which are those that do not involve murder, manslaughter, or rape. In addition, the district court has the authority to hear civil cases in which the disputed amount does not exceed 3 million Hong Kong dollars. One well-known case in the past was the Young Key case. Was it a case involving more than $3 million? Yes, that's right. Therefore, it was not tried by the district court, but by the Court of First Instance of the High Court. The lowest level of court is the Magistrates' Court, which specializes in hearing least serious criminal offenses, and the sentences it imposes are relatively light, mostly fines and conditional discharge. Examples of such offenses include unlicensed street vendors and enticing others to engage in immoral behavior, which are considered relatively minor offenses and can be adjudicated by the Magistrates' Court. We often hear the term tribunal in Hong Kong, such as the MMT, Market Misconduct Tribunal, and the Lands Tribunal. These actually belong to the administrative tribunals. So, is an administrative tribunal a court of law? No, it is not a court of law, so you won't see it on the organizational chart of the courts on the right-hand side of the PowerPoint slide. What types of cases do the administrative tribunals handle? As mentioned earlier, tribunals are not courts, so they cannot handle criminal cases. It can only handle civil cases. Here's a key point to remember, as it often comes up in exams: is the MMT a court of law? Or is it a higher court? If you see this type of question, just remember that whenever you see the term tribunal, it is not a court of law, cannot handle criminal cases, and cannot impose imprisonment. What is the difference between the administrative tribunals and the court? Remember, the purpose of the administrative tribunals is to quicken the legal process. In terms of legal process, the courts can be quite lengthy, costly, and time-consuming, while the administrative tribunals will be simpler. Similarly, because the goal is to be fast, the administrative tribunals have a more lenient requirement for levels of proof than the court, making the processing time of cases shorter than that of the court. Both handle cases differently, with the administrative tribunals only handling civil cases, while the courts handle both civil and criminal cases. Are there some examples? The courts include the Court of Final Appeal, the High Court, the District Court, the Magistrates' Courts, etc., while the administrative tribunals include the Market Misconduct Tribunal, the Securities and Futures Appeals Tribunal, the Lands Tribunal, the Labor Tribunal, etc. Based on the above differences, the administrative tribunals are not courts and are not within the court structure. The entire legal process is simpler and faster than the court. Is arbitration considered part of administrative tribunals or courts? Neither. It does not try and judge. What does arbitration mean and what is its purpose? When a dispute arises, both parties may seek a mediator to act as a middleman and make a decision based on the dispute. This process is called arbitration. Arbitration is mainly used to handle commercial disputes, which are civil issues. When both parties face a dispute and do not want to involve the court or administrative tribunal, they may use arbitration to resolve the issue. The mediator is neutral and can be more than one person to handle the dispute. How is it different from the court? The biggest difference is that the result of arbitration is not appealable, while the court decision can be appealed. Compared to the court, arbitration fees are cheaper and faster, and the process is informal and private, meaning that the dispute does not need to be made public. However, the arbitration result is still binding and must be accepted and followed by all parties involved. Where does arbitration take place in Hong Kong? The Hong Kong International Arbitration Center provides domestic and international arbitration. When would arbitration be used in Hong Kong? Under the SFO, Securities and Futures Ordinance. Disputes related to leveraged foreign exchange trading can be submitted to arbitration. Besides the benefits mentioned in the study notes, are there any other benefits? As mentioned earlier, the benefit of arbitration is that the process is informal and private. If a bank and an old lady take a case to the Hong Kong International Arbitration Center and the old lady loses, she cannot publicly expose how unfair the decision was. In contrast, if the dispute is handled in court, the proceedings are public, and others will know the outcome, preventing the possibility of being bullied by a stronger party. In this case, the greatest benefit of arbitration is the ability to handle disputes privately. In recent years, the government has conducted a lot of promotion about arbitration, making the general public more aware of what arbitration is. Okay, let's talk about the new CO. Company Ordinance. What is the new CO about? Actually, the new CO replaces the old Company Ordinance. As soon as you hear the word Ordinance, you know it's about the law, mainly regulating the formation and operation of companies and so on. So, what are the special features of the new CO? It specifies that only one person is needed to form a company. If a company has only one member, then this member is the shareholder, meaning the boss who invests money. So as long as there is one boss, a company can be formed, and one member already constitutes a quorum for a meeting of a company having only one member. A company is a legal person distinct from its members. In other words, once you establish a company, you and the company are no longer related except that you are a member of the company, i.e. a shareholder. As the owner of the company, you contribute money to the company. So why do we say that the company is distinct from you? Because once you establish a company, you can sell it or dissolve it, in other words, transfer the ownership of the company to someone else. The company can be separated from you. Therefore, the company is distinct from you and will only cease to exist if it is dissolved. So what can a company do? A company can do things like a normal person in the name of the company, such as making contracts, taking legal action, suing and being sued, owning property, and even committing crimes or torts. Can a company exist forever? As mentioned earlier, a company exists permanently unless it is dissolved by someone. If it is not dissolved, it can exist forever. Even if a shareholder dies, the company will continue to exist, like ATV. There are many types of companies, but the most common is a limited company. What is a limited company? It means that the liability of the company's members is limited. For example, if the company loses money, it does not affect the shareholder, and the shareholder does not need to use personal assets to pay off the debt. What are the types of companies in Hong Kong? There are three types: private companies, public companies, and guarantee companies. Every Hong Kong company belongs to one of these three types. There is no other type. What is a private company? Private company refers to a company that is established by oneself and may not have more than 50 members. The members referred to here are shareholders or bosses. As for shares, they cannot be freely transferred, sold to the public, or issued debt securities to the public. In other words, it is not possible to borrow money from the public. Moreover, private companies are not guarantee companies. What is a guarantee company? Will be discussed later. Are there any examples? For example, there is a well-known stationery company called
Changnam Book and Stationery Company Limited.
It used to have a large store on Sai Yung Choi Street South, and the boss's surname was Sure. This company is a private company. What does a public company include? A public company is a company that does not meet the requirements of a private company that we mentioned earlier, nor is it a guarantee company. Remember that in Hong Kong, all listed companies are public companies. So if you see a stock that is listed, the company of that stock must be a public company. To clarify, does a public company have to be listed? No, a public company doesn't have to be listed. To sum up, a public company is not a private company or a guarantee company. All listed companies in Hong Kong are public companies, but not all public companies need to be listed. Do you have any examples? Café de Coral Holdings, Limited is a public company. When it comes to listed companies, what are they? By definition, a listed company is one that has any of its shares listed on a recognized stock market, such as Café de Coral and PCCW, which were mentioned earlier. These are all listed companies. So to reiterate, listed companies are inevitably public companies. The third type of company in Hong Kong is a guarantee company. So, what is a guarantee company? A guarantee company is a very special type of company. It has no share capital, which means it has no shareholders or owners who have invested in the company. When the company is liquidated, the liability of its members is limited to the amount they have agreed to contribute. Generally speaking, these guarantee companies are non-profit organizations or belong to professional groups such as the Hong Kong Securities and Investment Institute, HKSI. As a guarantee company with no share capital, it does not distribute dividends. So remember, when establishing a company, we must have a document called Articles of Association. So, what is the Articles of Association? The Articles of Association describes the agreement between the company and its members. At the same time, this document also specifies regulations for the internal management and operation of the company. Generally speaking, what are the contents of the Articles of Association? First, officers, including powers and duties of directors, how to appoint and disqualify directors, how to appoint and remove company secretaries. Second, members, which means what responsibilities the boss has, how to vote, and how to hold meetings, are all things that need to be known. Third, capital, such as share capital. If you are a private or public company, you will naturally have stocks, which is share capital. Such as how to buy and sell, distribution procedures for dividends are all stated. Fourth, other miscellaneous provisions, such as how the company communicates with shareholders. Through the Articles of Association, we can understand the above-mentioned matters. According to the new CO. Companies Ordinance, shares in a company have no nominal value, and there is no requirement for the company to have authorized capital. However, you don't need to know these details because they are not examinable. All you need to know is that shares represent the money you put into the company. In other words, if you are the boss or a member of the company, the amount of money you contribute determines the amount of share capital you have. What can be included in the share capital? There are three types: after you contribute money, the company may offer you ordinary shares, preferred shares, or something called redeemable shares. I will explain their characteristics later. What are ordinary shares? Ordinary shares are actually the most common type of stock. It represents ownership in a company held by its shareholders. As a holder of ordinary shares, are entitled to share in distributions of past and current profits. This means that when the company makes money, you get a piece of the pie. Note that as holders of ordinary shares, the dividends you receive are not fixed and may not be specified in advance. In addition, dividend payments are prioritized, with debenture holders and preference shareholders receiving payments before holders of ordinary shares. We will explain what debenture and preference shares are in a moment. Furthermore, if the company winds up, holders of ordinary shares will be the last to receive any remaining value. If the company is unable to pay its debts or unable to pay its preference shareholders, then the holders of ordinary shares will not receive any money. However, if the company still has money left over after paying its debenture holders and preference shareholders, then it will distribute that money to the holders of ordinary shares. In short, holders of ordinary shares are the riskiest investors, ranked last in dividend payment priority, and with no fixed dividend payment. Once the company winds up, holders of ordinary shares may end up with nothing. However, as the saying goes, with risk comes reward. Because the dividends paid to the holders of ordinary shares are not fixed, if the company performs well, the profits distributed to common stockholders can be the highest. This passage discusses dual-class shares. What does it mean? In fact, dual-class shares, also known as weighted voting rights, WVR, where rights refer to the voting rights of shares. In simple terms, a company will issue at least two types of stocks with different voting rights per share. The first type, privileged shares, are usually held by founders or those controlling the company, with each share having more than one vote. The second type, common shares, are mostly held by ordinary investors, with one share and one vote. If it is a private company, there is no restriction on this dual-class share structure. However, if it is a listed company adopting this structure, the situation is different. From the 1980s to 2018, there were no dual-class shares in Hong Kong-listed companies, meaning that it was one share and one vote. After 2018, the HKSI relaxed restrictions, and companies adopting dual-class share structures could be approved for listing as long as they met the conditions specified in the listing rules. Everyone is very familiar with the Chinese brand Xiaomi Group, which was the first company in Hong Kong to go public in this way. As for the conditions that need to be met, we will discuss them in detail in Chapter 8. What are the advantages and disadvantages of this dual-class share structure? For founders or those controlling the company, holding privileged shares allows them to have greater control over the company and make decisions more easily. It also prevents external investors from taking control of the company through share acquisitions, which is beneficial for the company's autonomy and innovative development. The disadvantage is quite obvious: the power may be overly concentrated, which could harm the interests of minority shareholders. What are preference shares? To issue preference shares, the company's articles of incorporation must authorize it. The main difference between preference shares and ordinary shares is that preference shares receive fixed interest, that is, the dividends are predetermined and it is clear how much shareholders will receive. Also, if the company goes into liquidation, preference shareholders have priority over holders of ordinary shares in receiving the remaining value of the company. However, keep in mind that, in the distribution of assets, preference shareholders rank after creditors. In other words, when a company's liabilities exceed its assets, the company will first repay the creditors with the remaining assets, then the preference shareholders, and finally the common stockholders. If there are no assets left after repaying the creditors, the preferred stockholders will not be able to receive any assets. There are also participating preference shares. Similarly, the holders can receive fixed dividends, additional dividends, and a portion of the remaining distributable profits, but this type is not very common. Generally, shares can be divided into redeemable and non-redeemable shares. What is a redeemable share? Hong Kong companies can issue redeemable preference shares and redeemable ordinary shares. The term redeemable means that after the shares are issued, following certain special events or specific periods, the company can buy back these shares from shareholders and cancel them. These are called redeemable shares. What are the issuance conditions for redeemable shares? First, the company's articles of association must permit their issuance. Second, they can only be issued when there are non-redeemable shares among the company's issued shares. How can shares be redeemed? How can a company buy back these redeemable shares? A company can redeem shares that have been fully paid for, which means that to redeem them, money must be paid. The sources of this money can be distributable profits, which is the money earned by the company, some new share capital, where the company issues new shares to raise funds for the purpose of redeeming the shares, and capital. In exams, knowing these sources should be sufficient. The most important thing is to know what redeemable shares are, which are shares that can be issued to shareholders, and then the company can buy back these shares from the shareholders. What is the impact of redeemable shares on a company? Once redeemable shares are redeemed, they will be canceled because the company has repurchased these shares from the shareholders. For example, if a company issues 100 redeemable shares and now 20 shareholders are willing to sell their shares back to the company can buy back 20 shares. Then, there will be only 80 shareholders holding 80 shares in the market, and the number of redeemable shares in the company will decrease. Therefore, once redeemable shares are redeemed, they will be canceled and no longer exist. The company needs to pay the shareholders to buy back the shares from them. If the source of funds is share capital, the company's share capital will decrease. If the source of funds is profit, the company will reduce the amount of profit distribution. If both of the above apply, the share capital or distributable profit will be reduced proportionally. Regardless of the method, the reduction should be equal to the total amount of the share purchase price. With this information, you should have a good understanding of redeemable shares. Let's talk about what debentures are. Essentially, debentures can be considered an IOU, but it is issued by a company. Those bonds you often hear about are a type of debentures. Remember, the holders of these debentures are creditors, not the bosses. Debenture holders can receive interest at a fixed rate, which is clearly stated on the debentures. This means the profit or return on the debentures is fixed. Note that every company must pay interest to its creditors before distributing dividends. As the saying goes, paying off debts is a moral obligation. So naturally, debenture holders receive priority in payment. If your company makes a profit and wants to pay shareholders first, is that allowed? The answer is no, the payment must be made to the creditors first. If a company goes bankrupt and liquidates, who gets priority in repayment? The answer is the creditors. If there is any remaining value, it will be distributed to the shareholders. In other words, if the company's assets are insufficient to cover its debts, even the creditors will not receive payment, and the shareholders will never receive any remaining assets. Just like shares, debentures can also be redeemable or non-redeemable. The special feature of redeemable debentures is that regardless of whether the company makes money or not, the company must pay interest on the due date and also redeem the debentures. Debentures can be secured and unsecured. If it is a secured debenture, the issuer, which is the company that wants to borrow money, will provide assets as collateral, such as real estate. When a company is winding up, the secured holders will have priority over the collateral. In other words, secured holders will be paid before unsecured holders. After repaying the debenture holders, if the company still has remaining assets, they will then be allocated to shareholders. So remember, when we usually start a company, we become the bosses of the company. Can we influence the company's decisions? Many people may think that since they started a company, they are the boss and can influence daily decisions. This answer is incorrect. Remember what we said before, a company is an independent legal entity, and it is separate from its owner, meaning the company members or shareholders. Therefore, shareholders do not participate in the company's daily operations. Let me give you an example. Suppose I invest money and start this company. I am the boss, and I am a member of the company. I hire a person named Miss Chan to be the director and manage the company. Miss Chan will act as a representative to run this company. Although I am the boss and have the right to sell the company, Miss Chan is not serving me but only the company I started. If shareholders want to participate in the company's administration or decide who should run the company, what can they do? They can attend the annual general meeting of shareholders, which is the only opportunity to interfere with the company's operations. In addition to the general meeting, we can also influence the company's operations under specific circumstances, such as holding a special meeting in response to the request of directors, shareholders, or the court. However, this situation is not common. How often should an annual general meeting, AGM, be held? Generally speaking, a company must hold a shareholders' AGM every year, unless an exemption is granted. Under what circumstances can an exemption be granted? A company can be exempted from holding an AGM through a written resolution or a resolution at a general meeting with unanimous shareholders' consent. How do we know when to hold an AGM each year? The first AGM should be held within 18 months of the company's formation, and subsequent AGMs should be held no more than 15 months apart. In theory, a company should convene its AGM according to its accounting reference period, which refers to the reference date of the company's annual financial statements. If it is a public company, an AGM should be held within 6 months after the end of their accounting reference period. If it is a private company or a guarantee company, an AGM should be held within 9 months after the end of their accounting reference period. What should be discussed at the annual general meeting, AGM? First, consideration of the annual accounts. For example, are the accounts for this year fair? Why are the accounts like this? Are there any issues in the auditor's report? Members have the right to raise these questions to the directors and auditors. Second, the declaration of dividends. If you are an ordinary shareholder, you can find out how much dividend will be distributed this year through the AGM. Third, the election of directors. If, for example, Director Ms. Chan wants to retire or is not performing well and a replacement is desired, this can be brought up at the AGM. Fourth, the appointment of auditors. Similarly, if there is a desire to change auditors, this can be addressed at the AGM. Members have the right to ask questions to the directors and auditors based on the annual accounts and annual report. As a member, in other words, a shareholder, what powers can be exercised at a general meeting? These include changes to articles of association, buyback issues, issuing new shares, changing the company's capital, altering the rights of various classes of shares, corporate restructuring and arrangements, appointing and removing auditors, removing directors, and disposing of company assets, etc. Essentially, members can raise these matters at a general meeting and have them addressed and resolved during the meeting. So, we often talk about voting, and we often say that shareholders can interfere with company activities at members' meetings. Does that mean shareholders can interfere immediately after speaking? No, generally speaking, we need to go through a resolution process. We have 3 types of resolution procedures. The simplest procedure is called a resolution. Shareholders do not need to do this at a general meeting. The company just needs to send a letter called a circularization to all shareholders. After receiving the letter, shareholders simply sign to confirm their approval. Remember, with this method, shareholders do not need to attend the meeting or raise their hands to vote. Their signature alone is sufficient for approval. This method is mostly used to decide on simple matters for the company, such as general administrative policies. So, what is a special resolution? The use of the word special implies that it concerns significant matters, including reducing share capital, winding up of the company voluntarily or by court, and amending articles of association. These are considered significant changes, so they need to be dealt with through a special resolution. What is the procedure for a special resolution, and what are the requirements? At a members' meeting, shareholders generally need to be present in person, unless they are allowed to appoint a representative to vote on their behalf. That is, they need to raise their hands to vote, and at least 75% of the members present must approve the resolution. Before calling a members' meeting, there must be a notice period of no less than 14 days to notify shareholders about the meeting. If a special resolution is passed, a copy of a special resolution must be lodged with the Registrar of Companies within 15 days of it being passed. So, what is an ordinary resolution? Compared to a special resolution, an ordinary resolution has lower requirements, but shareholders still need to attend the members' meeting and raise their hands to vote in order to pass the resolution. It only requires the approval of shareholders with more than 50% of the voting rights. So, what are the usual matters for an ordinary resolution? Removing directors, appointing new directors, as well as removing auditors and appointing new auditors. These matters cannot be approved through circularization, they must be passed through an ordinary resolution. Whether you become a member or shareholder of a company by starting a company or buying shares, even if we find a good director, there's a chance they might take advantage of us, right? So, how can we protect the rights and interests of members or shareholders? When we feel that a director is not suitable, and we want to take action, there are several things we can do. First, if it concerns internal management matters, the company can call a general meeting for members to handle the issue themselves. Do you remember what we said could be done at a general meeting? We can remove a director. So, if we find members with 5% of the voting rights who feel it's necessary to address the issue, we can request the director to call a members' meeting. If the director deliberately refuses to cooperate and rejects the request to convene a meeting, what can we do? In that case, we don't need to deal with the director. As long as we meet the quorum requirements, we have the right to call the meeting ourselves and then remove the director. Second, we can request the financial secretary to appoint an inspector. If we have people with 10% of the voting rights, or not enough voting rights, but can gather 100 small shareholders, and everyone wants to know if there are any situations detrimental to shareholders, we can request the financial secretary to appoint an inspector to investigate the company's affairs. The third way is to petition the court and have the court intervene in handling the matter. Generally, courts will not intervene in the internal affairs of a company, but there are a few situations in which they can do so. When a company varies the rights of the holders of a class of shares and 10% of the shareholders believe that the shareholders' rights are being harmed. In this situation, they can petition the court, requesting the court to cancel the decisions made by the directors and cancel the changes. Whether or not the court will do this is up to the court to decide, and the court's decision is final. In addition, if they feel that the way the company is currently operating is damaging to the general shareholders or some shareholders' rights, such as transactions conducted by the directors that are detrimental to shareholders, then they can petition the court, asking the court to investigate the matter. At the same time, they may apply to the court for an order to stop such behavior. When a member feels that there is a problem with the company, as a shareholder, he or she has the right to petition the court, regardless of the number of shareholders, for a winding up. As a company is a legal person, if the company breaks the law or encounters problems that affect the interests of its members, members can file a lawsuit against the company through the court, allowing the court to intervene and handle the matter. For example, if the personal interests or group interests of the members are infringed upon, the court can sue the company or affect its operations. There are several types of actions in this situation, including personal actions, which represent individual members suing the company, a joint action, where several members sue the company together, or if it is discovered that members representing the company, such as directors, have engaged in improper conduct against the company, we can also sue them, which falls under the category of a derivative action. What senior personnel does a company have? An officer includes a director, manager, or company secretary. They are the senior personnel in a company. For every company that is not a private company, there must be at least 2 directors. What are non-private companies? As mentioned earlier, these are guarantee companies and public companies, which require at least 2 directors. For private companies, there must be at least 1 director who is a natural person. How are directors appointed and who appoints them? Directors must be appointed by the members acting in a general meeting, where the members are shareholders. Can a director choose themselves? No, the decision must be made by the members. What are the responsibilities of a director? A director represents the company and manages its general business affairs, exercising all the powers of the company. What is a shadow director? A shadow director, as the name implies, is a behind-the-scenes operator. It is important to remember that as a shadow director, the person is not a director themselves. Rather, the majority of the board of directors of a company acts according to the wishes of this person or group, so this person or group becomes the shadow director. For example, if I am the founder of a company, but have retired, the current directors may still believe that my decisions are worth respecting and may follow my commands or suggestions most of the time. In this case, I would be a shadow director of the company. However, professional individuals such as accountants or lawyers are not considered shadow directors. Why? Because they are providing professional advice on legal or financial matters, and if you follow their advice, it is not because they are shadow directors, but because they are professional. Therefore, they are exempt from being considered as shadow directors. So, let's review. Is a shadow director a director? No, a shadow director is not a director. Is a lawyer a shadow director? No, professionals are not considered as shadow directors. What are the qualifications for being a director? Who can be a director? First, you must be at least 18 years old. Second, must not be undischarged bankrupts, meaning you have been discharged from bankruptcy. Third, you must not be disqualified by court order. What actions can lead to disqualification by court order? For example, if you have served as a director of an insolvent company, a company with liabilities exceeding assets, and the court believes that you intentionally failed to fulfill your director's responsibilities, or judges that you are not suitable to be a director, then you may be subject to this legal order. Will you be disqualified as a director if the company is insolvent? Not necessarily. As long as the court believes that you have done your best to handle the situation, you will not be subject to this legal order. Fourth, you must not have a history of fraud, dishonesty, or disqualification. Once you have such a record, you will be unable to serve as a director in the future, even as a shadow director. What powers do directors have? Remember, directors are not essentially bound by resolutions passed by members in a general meeting. Directors can do many things that other members have not proposed or moved. All right, now I want to ask you, will members participate in the company's management affairs? The answer is no. Generally speaking, members cannot interfere with the decisions of directors. Do you remember any methods for members to change the director's administrative approach? That is to call a general meeting and pass some resolutions to interfere with the operation of the company's management. Are there any situations that would cause members to intervene in management affairs? For example, if a director is unwilling to take action, if a director wants to act beyond their powers, that is, doing something that the company's articles of association say cannot be done, in this case, the members' permission is required, and the members must pass an ordinary resolution to approve this action. Moreover, if a director is disloyal and breaches their fiduciary duty, the members may ratify such breaches in general meeting. Only in these special circumstances can members intervene and make decisions through resolution methods, such as whether or not we approve the director's actions or if we need to replace the director, etc. In addition to shareholders holding annual general meetings, directors also need to hold board meetings, which simply put, are meetings held by the directors themselves. Who says that a board of directors meetings needs to be held? Remember that under common law, Directors should hold board of directors meetings regularly, mainly to decide on the company's important administrative affairs and make resolutions. The resolutions passed also need to be recorded in writing, clearly written in black and white, which can be used as evidence to prove that the resolutions were passed at a board of directors meetings. What else should you know? Similarly, board of directors meetings require a proper quorum, and the board can delegate its powers to individual directors, to committees, and to the managing director. Therefore, the board can exercise its power even without calling a meeting. As mentioned earlier, since directors are representatives of the company, there is an agency relationship between directors and the company. Speaking of agency relationships, do you still remember the responsibilities of an agent? They owe another person duties of good faith, trust, confidence, honesty, and care, and have a duty to act for the benefit of the other. Since the director is a representative of the company, there is an agency relationship between the director and the company. Directors are actually employees, working for a salary, and their remuneration is called director's remuneration. The company is the principal, and the director is the agent, so the director naturally has a fiduciary duty. Therefore, directors need to be loyal to the company and sincerely work for the company. Remember, always put the company's interests first, use the director's power appropriately, and ensure that there is no conflict of interest between the director's duties and the company. If there is any conflict of interest, the director has the responsibility to explain it to the shareholders at the general meeting. Directors also need to possess a certain level of ability, with reasonable performance and skills. As the saying goes,
Beauty is in the eye of the beholder.
So how do we judge whether a director's performance is reasonable? Does it meet the reasonable level of care, skill, and diligence required by the company's ordinance? First, directors should pass an objective test, which means comparing horizontally with others, such as professionals in the same industry. We can reasonably expect the performance of others when they are performing directorial duties, such as general knowledge, skills, and experience, and then evaluate whether the director meets the required level. In addition, directors also need to pass a subjective test, making a vertical comparison, that is, examining whether the director's relevant knowledge, skills, and experience are ideal. Vertical comparison mainly considers the director's background, education, and experience. Directors are like men who have to shoulder various responsibilities. In addition to the fiduciary and statutory duties we mentioned, directors also have to bear specific responsibilities. So, what does this include? Remember, a director is a representative of the company and should ensure that the company operates legally, fairly, and reasonably. If a director fails in his duties, that is, fails to fulfill the responsibilities of a director, he will be held accountable under the law. For example, if the company makes an untrue statement when selling shares to the public, the director may be fined or even imprisoned. What are some other examples? For instance, the company's ordinance requires directors to submit financial statements annually, but the director doesn't do so, resulting in the company breaching the requirement of the CO. Since a director's responsibility is to ensure that the company operates at least at a level that meets legal requirements, the director will be held responsible if he intentionally does not prepare financial statements or deliberately fails to do so. On the other hand, if a director tries his best to prepare financial statements but fails due to a natural disaster, such as an earthquake, it is not the director's responsibility. The director has not failed to fulfill his duties, as earthquakes are unpredictable and beyond the director's control. Unlike in reality, the focus of the exam is on right and wrong, with no gray areas. Strong emphasis is usually placed on words like
completely disregards,
negligence, etc., so you can pay attention to these words and use them as a basis for making judgments when answering questions in the exam. So, if the director is really messing things up or can't do the job, what can we do? First, we can ask the court to issue an injunction to prevent the director from continuing their duties, stopping their role immediately. Note that this can be issued by the court, not by the members. Second, if the director is acting dishonestly while representing the company, such as taking advantage from other companies and not disclosing personal interests, then in this situation, the members can choose to terminate the contract made with the director. In another case, if a director has made mistakes that cause the company to suffer losses, all the directors involved should also bear joint responsibility for the losses. Third, if the director obtains improper benefits from handling the company's property, they should, in principle, be accountable to the company, for example, by looking at how to return the assets to the company or how to compensate the company. So, if a director makes a mistake, can I forgive them? In principle, it is possible. For the director's breach of duty, the company's members can hold a general meeting to make a resolution, to see if the members agree to pardon the director's breach. If the members pass the resolution, approving the pardon of the director, then we can forgive the director. Second, if the director can prove that their breach of duty was based on an honest, reasonable, and reliable situation, then they fundamentally don't need to bear responsibility. How is this? It means that the director proves they made the best choice based on the information they knew at the time, or did their best to solve the problem, but inevitably made a mistake. In this situation, the court may give relief to the director. As a director, if I have a conflict of interest with the company, what should I do? Should I report it after the conflict of interest arises, or should I report it before the conflict of interest arises? Better safe than sorry. Remember, as a director, if you think that doing this thing might have a conflict of interest in the future, you should immediately inform the other directors. Even if the deal does not go through or is not completed in the end, you still need to report it. Ideally, before conducting the transaction, the moment you realize there's a conflict of interest or when you know it will arise, you should immediately inform the other directors, report the case. Okay. Between a director and a company is an agency relationship, with the company being the principal and the director being the agent, representing the company in its affairs, which is essentially working for the company. So, do employees get paid? Of course, directors receive a director's remuneration, which is the compensation paid by the company to the director. Where can we find information about the director's remuneration? It can be found in the company's articles, which will tell us the amount of the director's remuneration. Who decides how much the director's remuneration is? It is decided by the members at the general meeting. Remember, the director's remuneration includes the director's fees, which is also decided by the members at the general meeting. If a director has other duties besides being a director, how is their salary calculated? The company can sign an additional service contract with the director, treating them as an ordinary employee and paying them extra money on top of their director's remuneration. Can directors borrow money from the company? Directors should not borrow money from the company unless it is approved by the company's members, which is the shareholders. In other words, the company should not lend money to its directors. Can the company guarantee a loan for a director? In general, the company cannot do so without the approval of its members. For example, if a person is a director of ABC Company and wants to buy a luxury property but doesn't have enough money, they might go to a bank for a loan. If the director tells the bank that they are a director of ABC Company, which is wealthy, and asks ABC to act as a guarantor, this action would not be allowed without approval from company's members. The company should not act as a guarantor in this situation. If the company cannot lend money to the director, can it lend money to the director's children, parents, or other companies? Lending money to companies or individuals related to the director, such as parents, children, or cohabitee, is considered as lending to the director. Therefore, the company cannot lend money in this way, and the director cannot ask the company for a loan. Are there any exceptions that allow the company to lend money to the director? The first exception is if the value of the loan does not exceed 5% of the company's net assets. In this case, the company can lend money to the director. The second exception is when the director has engaged in improper conduct, causing losses to the company, and the director must repay the company as compensation. Under this situation, the company can lend money to the director. For example, if the director caused the company to lose $5 million during their work and they don't have the money to repay it, they can ask the company for a loan. This is considered an exemption because the director's wrongdoing caused the loss, and it is not a specific loan. The director is unable to compensate for the loss immediately, so it is treated as a loan as a last resort. As a commercial entity, a company naturally has many accounts, which need to be audited and investigated. So, which types of people can conduct investigations on company audits? First, it is the company itself. If the company suspects that its accounts are questionable, the company may itself carry out a private investigation. Apart from the company, if the financial secretary believes that an investigation is necessary for a company, he has the authority to order an investigation. Furthermore, if a court declares that an investigation should be carried out, the financial secretary is required to appoint inspectors to investigate, and after the investigation, a report on the affairs of a company should be made to inform everyone of the investigation results. There are several situations under which the financial secretary can appoint an inspector to investigate a company. For example, the first situation is when the financial secretary receives a request for an investigation from the company's members. Remember that we mentioned earlier, if a company is suspected of violating the rights of shareholders, as long as 100 shareholders are gathered, or shareholders with a combined 10% voting power meet the specified number of members requirements, they can apply to the financial secretary for an investigation of the company. Additionally, if the company's general meeting passes a special resolution to appoint an inspector, the financial secretary must comply and arrange for an inspector to conduct the investigation. The third situation is when the financial secretary has suspicions about the company. For example, if HR suspects that there is improper conduct in the company's business or composition, which may harm the interests of the company's members or creditors, they can order an investigation into the company to see if anyone is engaging in fraud or other misconduct. When the inspector receives the appointment, they will proceed with the investigation. During the investigation, do the company's personnel need to assist the inspector? The answer is yes. Basically, all personnel of the company have a responsibility to provide assistance to the inspector. If they do not cooperate, the inspector can go to court and compel them to provide assistance. However, the inspector cannot force two types of individuals to cooperate. First, the inspector cannot force a lawyer to provide privileged communication. What is privileged communication? It refers to the communication between a lawyer and their client, which may involve legal opinions and confidential information helpful to litigation. Therefore, the inspector cannot compel a lawyer to provide such privileged communication. Second, the inspector cannot force a bank to provide information unrelated to the company under investigation. In other words, when the inspector requests information from the bank can cooperate and provide the relevant information of the investigated company. However, the bank has no responsibility to provide information beyond that company to the inspector. There are mainly two ways for a company to liquidate. The first one is called compulsory liquidation, and the second one is called voluntary liquidation. For voluntary liquidation, there are two types: members' voluntary winding up and creditors' voluntary winding up. In the following sections, I will explain in detail. So, what exactly is compulsory liquidation? Well, remember that compulsory liquidation is ordered by the court. The court has the authority to appoint a liquidator, who could potentially be the official receiver, and this liquidator needs to handle the matters under the supervision of the court. So, who can petition the court to enforce a compulsory liquidation? Petitioners can come from the company, a creditor, a contributory, in other words, every person liable to contribute to the assets of a company in the event of its being wound up, the financial secretary, the registrar of companies, the official receiver, or the Securities and Futures Commission. These people may petition the court, and then the court may issue an order. Compulsory liquidation is initiated by a court order, so the liquidation process is more complicated. So, what are the circumstances of court winding up? A company may be wound up by the court if the company has already held a special resolution, deciding that the court should help the company proceed with liquidation. Also, if it does not commence its business within a year from its incorporation, it has suspended its business for a whole year, it has no members, it is unable to pay its debts. Moreover, if the company's articles of association specify that certain events would trigger compulsory liquidation, and if such an event occurs, compulsory liquidation must proceed. At last, if the court is of the opinion that it would be just and equitable to wind up the company. For example, if the company has been involved in many fraudulent activities in the past, if it has failed to achieve its main object, or if there has been a long-standing lack of mutual trust, understanding, and confidence among shareholders and directors, the court will proceed with liquidation. Another way of liquidation is called voluntary liquidation. A voluntary liquidation can be initiated by members or creditors. Since it does not involve the court, it requires fewer formalities. So, under what circumstances will voluntary liquidation occur? One possibility is that the company's duration comes to an end. How do I know when the company's duration comes to an end? The company's articles of association will state this. For example, if it specifies that the company will only exist for 10 years, and now 10 years have passed, the time has come, so a voluntary liquidation must be carried out. Second, a company can decide to voluntarily liquidate by passing a special resolution, which requires the approval of at least 75% of the members. Regardless of whether there are financial difficulties, the company can call a general meeting at any time to liquidate and close the business. Third, if more than half of the directors believe that liquidation is beneficial because the company has too much debt and it is difficult to continue operating, a winding up statement can be delivered to the Registrar of Companies for voluntary liquidation. So, what needs to be written in this winding up statement? It declares that the resolution to liquidate the company has been passed at a meeting. Remember that no later than 28 days after delivery of any winding up statement to the Registrar of Companies, a company meeting must be held. Voluntary liquidation is divided into members' voluntary winding up and creditors' voluntary winding up. Members' voluntary winding up, as the name suggests, is the voluntary dissolution of the company by its members. If a member's voluntary winding up is to be carried out, the directors must issue a certificate of solvency to the Registrar of Companies. So, what needs to be declared in this certificate of solvency? First, the directors have made a full inquiry into the affairs of the company. Second, the directors believe that the company can pay its debts within 12 months from the commencement of the winding up. Remember, the company can only proceed with members' voluntary winding up if it satisfies the above conditions and issues this certificate of solvency. Otherwise, it will become a creditor's voluntary winding up, which we will discuss next. To conduct a member's voluntary winding up, a certificate of solvency must be submitted. So, what needs to be done in terms of procedure? The company should issue a certificate of solvency within 5 weeks, or 35 days, preceding the resolution to carry out members' voluntary winding up, or be delivered to the Registrar of Companies for registration not later than when the copy of the winding up resolution is delivered. How can the company's financial situation be proven? The certificate of solvency must include a statement of the company's assets and liabilities at the latest practicable date. Let me test you now. If we think that the company needs to be liquidated now, but its liabilities still exceed its assets, can we issue a certificate of solvency? Under this situation? The answer is no, because we do not have the ability to repay the debts. If we cannot issue a certificate of solvency, can we carry out a member's voluntary winding up? No, because one of the necessary conditions for members' voluntary winding up is to have the ability to repay debts. Alright, so the company needs to liquidate now, but its liabilities exceed its assets and it cannot issue a certificate of solvency. What can be done in this situation? In this case, the company must undergo creditors' voluntary winding up. So, what is creditors' voluntary winding up? Remember, any voluntary liquidation that does not meet the conditions of members' voluntary winding up falls under Creditors' voluntary winding up. Once the company resolves to voluntarily liquidate and dissolve, the company must arrange a creditors' meeting within 14 days, with at least a 7-day notice period, and importantly, advertisements must be run in the Gazette and newspapers. Who should be notified? The creditors, that is, the debt holders, are invited to the meeting. So, what will be done at the creditors' meeting? A statement of the position of the company's affairs will be presented, a liquidator will be appointed, and a committee of inspection will be appointed to supervise the process. Who appoints the liquidator and establishes the committee of inspection? Is it the members? No. As it is a creditors' meeting, the creditors lead the process, so the creditors will decide at the meeting who to appoint as the liquidator. The members can make nominations, but the creditors also have the right to choose who will be the liquidator. In addition, the creditors will establish a committee of inspection to supervise the liquidation process of the company. Here, we've created a table to help differentiate the different types of company liquidation. Firstly, liquidation can be divided into two main categories: compulsory liquidation and voluntary liquidation. The difference between the two is that compulsory liquidation is ordered by the court and is executed externally, while voluntary liquidation is carried out by members and is internally executed. Under what circumstances will compulsory liquidation occur? Reasons for adopting compulsory liquidation include: the company passes a special resolution to have the court carry out the liquidation, does not commence its business within a year from its incorporation, or has suspended its business for a whole year, the company has no members, in other words, no shareholders or financiers. The company is unable to repay its debts. Or, the company experiences an event that meets the dissolution conditions specified in the Articles of Association, or, the court is of the opinion that it would be just and equitable to wind up the company. Under what circumstances will voluntary liquidation occur? For example, when the period fixed for the company's duration as stated in its Articles of Association comes to an end, or the decision to wind up the company is made through a special resolution at a general meeting. The reason for liquidation is not important. What matters is that 75% of shareholders agree to dissolve the company. Or, if a majority of the directors believe the company can no longer continue operations and deliver a winding up statement to the registrar, voluntary liquidation can be carried out. Of course, in this case, it is usually due to insolvency. There are two types of voluntary liquidation: members' voluntary winding up and creditors' voluntary winding up. Which method is used depends on the company's ability to repay debts. A company with the ability to repay debts can undergo members' voluntary liquidation. As evidence of the company's debt repayment ability, directors must issue a certificate of solvency indicating that they have conducted a comprehensive investigation of company affairs and formed the opinion that the company will be able to fully repay its debts within a period not exceeding 12 months from the commencement of voluntary liquidation. If a company is unable to repay its debts, or if its debt repayment ability is insufficient to repay all its debts, or if its debt repayment ability exceeds available assets, it can only undergo creditors' voluntary winding up. Remember, if the company is unable to issue a certificate of solvency, it will be considered as a creditor's voluntary winding up. Are you preparing for HKSI, MPFE, IIQE, EAQE, or SQE examinations? Look no further. At 2C Exam, we have everything you need to succeed. Our comprehensive suite of products and services includes premium online and offline question banks, personalized one-on-one tutorial sessions, tailored group classes, and private consultation sessions. Need assistance with licensing or examination inquiries? Don't hesitate to get in touch with our knowledgeable team. We're always here to help. We're open Monday to Friday, from 9 a.m. to 12 p.m. and 1 p.m. to 6 p.m. You can reach us by phone at 211-09644 or send us a message on WhatsApp at 934-72064. Need to send us a fax? Our fax number is 211-19644. Prefer email? Drop us a line at info@2cexam.com. And don't forget to connect with us on WeChat, HK2C Exam. Choose 2C Exam, your path to exam success. Reach out to us today and let us help you achieve your goals.